Hello and a warm welcome to HW News Network, your one stop show, truth be told, for some engaging and thought provoking conversations. Supreme Court today called the Bihar Special Intensive Revision row largely a trust deficit issue, as the Election Commission of India claimed roughly 6.5 crore people of the 7.9 crore voting population didn't have to file any documents for they or their parents featured in the 2003 electoral roll. Now, the top court is hearing a batch of petitions against the Election Commission's electoral roll revision exercise in Bihar, and a bench of justices Surikant and Joy Malia Bakchi during the hearing remarked that it largely appears to be a case of trust deficit, nothing else, as it questioned the petitioners challenging the EC's June 24 decision of conducting the SIR on the ground that it would disenfranchise 1 crore voters. Now, what did the bench say? The bench said that if out of 7.9 crore voters, 7.24 crore voters responded to the SIR, it demolishes the theory of 1 crore voters missing or disenfranchised. This is what the bench told Kapil Sibal, who was the lawyer for the RJD leader Manoj Jha. Now, the top court also agreed with the EC decision to not accept Aadhaar and voter cards as conclusive proof of citizenship in the ongoing exercise, and said that it has to be supported by other documents. In fact, Kapil Sibal said that despite the residents holding Aadhaar, Ration, and Epic cards, officials refused to accept the documents. Then the bench said that is it your argument that people who have no documents but are in Bihar and therefore he should be considered as a voter of the state? That can be allowed, and he has to show or submit some documents. This is what the bench said. Now, when Kapil Sibal said that people were struggling to find birth certificates and other documents of their parents, Justice Surikant said that it is a very sweeping statement that in Bihar nobody has the documents. If this happens in Bihar, then what will happen in other parts of the country? In fact, Abhishek Manu Singhvi and Prashant Bhushan, who are representing the different political parties, also questioned the timeline for the completion of the exercise and the data of 65 lakh voters who were declared as dead or migrated or registered in other constituencies. In fact, Yogendra Yadav uh, got two people before the court, and he presented two of them before the court who were alive and they were declared as deceased. To that, Rakesh Dwivedi, who was a lawyer of the Election Commission, said that what is this drama going on, and why don't you help these two people in uploading their enumeration forms? So this kind of an argument which went on day one. The big question we are asking, that is Supreme Court seemingly backing the Election Commission? Is it speaking the language of the ruling dispensation? Is it speaking the language of the Election Commission of India? And is there any hope now left on the SIR case? Joining me this evening is renowned election data scientist Dr. Pyarelal Garg, who's also a renowned academician. Dr. Garg, thank you so much for joining. What would you really say to the day one hearing, which resumed in the Supreme Court, and of course it's going to resume tomorrow as well? What are the big takeaways according to you from day one hearing on SIR?
So, thank you, Neelu, asking me to join this discussion. Basically, when the Honorable Supreme Court says about 6.5 crore or lakh, 65 lakh or 6.5 million people. Now, the figure is with me. Uh, 65 lakh, 64,075 people have been removed. This is a chart, district-wide chart with me. And the other thing that they say all over India, the similar figure and all that, there is a lot of variation amongst the removals in 38 districts of Bihar. What to talk of 800 districts of the country. There's a Gopalganj district where 15.1% people, 10% people have been removed. And it is said that this district has the maximum population belonging to the minority categories. Now, second, when they say your 1 crore voter, the figure is wrong. Now, I will tell how is it right. Now, there are so many, these are the people, on one side, the election commission is making a false claim that they have done SIR. They have done it as per 2003. This is nothing but whimsical. Now, if they have done this, why do they say that the 65 lakh people which they have removed, 6.5 million people who have been removed. 2.2 are dead. Who say 2.2, whether they were dead in 2003 or now, they are dead in any case. They are to be removed now. What is the why? What is the relevance of 2003? They are dead and they are dead. Two, 3.5 million, 35 lakh. They say have shifted permanently. Now, if they have shifted permanently, whether they shifted in 2004, 5, or even 2024, how does it matter? 35, how do they say that it is SIR? This is a simple revision. Even in simple revision, if the people are not residing at the place as per the law, they have to be removed. Otherwise, also. Three, they say 7.5 lakh were, now they say 7 lakh. Earlier they said 7.5 lakh are duplicate voters. If they are registered at two places, they have to be removed from one place. How does the SIR give them any revision will do it? They say 1 lakh people are not traceable. If the people are not traceable, how can they be entered in the? So what is the SIR? 65 lakh people which they have removed, they conform to the standards of a routine revision, whether it is an intensive revision or it is a summary revision. It is a revision before any electoral exercise in the country, whether it is assembly election or it is a Lok Sabha election. So this is a simple removal. They're saying SIR, SIR, SIR. So now we say, come to the other thing. Now we come to the fact that the BLOs, I'm not going to right now, later on I will come to that.
Yes.
There are so many columns, the draft electoral roll, which has been put up, uploaded by the Election Commission of India. In that, there are so many columns, vectors where it is written BLO has not recommended. Now, what do they mean by BLO has not recommended? No, we will take it that if the BLO has not recommended, it means their names will be removed. Of course, by seeing whether they belong to BJP or to the opposition. One, two, whether they are belonging to minority community of the country or to the majority community, whether they belong to scheduled caste or to the other Savarna Jatis, whether they are ruralites or they are the urbanites. So that is a total discrimination which our constitution prevents. This is what they are going to do. Why are they not telling, if Yogan Jha said that out of 56 lakh at that time when he studied, 31 lakh are the women who have been removed and 25 are the male. It means there is the female population is lesser than the male population, total population. Similarly, number of female voters is lesser than the male voters. However, the removal of the female voters is much more than the male voters. It is a discrimination against the woman. It is against the Constitution of India. It is a negligence of the elector, you can say, the ECI. So the Supreme Court is not, then they say, some document. Now, some document is prescribed already. How can the Supreme Court say we will prescribe this? Let them change the election law. The document is prescribed the Aadhaar card. And Supreme Court says no, we will not accept it. Because the election commission said, earlier, why did they say it? One more, because to your comment, which the bench has made a comment. Okay, that way, whole of India will not be having it. Suryakant ji, Justice Suryakant has made it. Let them say on the first day, they said the honorable judge who was heading the bench, he said, I also don't have these documents. Was he telling a lie? Was he making a wrong statement? Will Justice Suryakant say that the so and so judge who was heading the bench, he has made a wrong statement? Will he tomorrow, as a Chief Justice of India, though the person stands retired, I suppose, or going to retire, Prachaji will tell, will he
Right.
take some action? Well,
Yeah.
these are
I
the issues.
put on your
One
thoughts.
line only. I am
Right.
saying that the Election Commission of India is trying to play with the democracy, play havoc with the democracy of this country, is trying to discriminate as the BJP wants to discriminate the population of this country. This country has a equal citizenry, but they want to divide and re-divide this citizenry into religion, into minorities, into castes, and all.
Right. Mahmood Pracha, Supreme Court lawyer and activist, also joins us. Thank you so much, Mahmood, for joining. Day one of the hearing of the Supreme Court on SIR hasn't been very encouraging. People have started writing about the fact that Justice Surikant and Justice Bakchi seem to be encouraging and supporting the election commission. They are speaking in the language of the election commission. What would you really say to the brazenness of the court on SIR, or rather an indifference to the problems which the citizens are facing on the ground? Despite all the exposes which have been done, the Supreme Court still doesn't seem to be looking into those problems. What would you really say on the takeaways of day one hearing on SIR? You'll have to unmute. You'll have to unmute, Prachan. Yeah.
See, I am the first person who said this. It's useless and it is pointless to go to courts, especially the Supreme Court, in matters like this, which have to be decided and settled on a political level, on a mass campaign level, and not at all at the Supreme Court level. The biggest danger one can walk into in such matters of such great importance is that one approaches the Supreme Court. Today, I am seeing a little positive thing, despite everybody else saying that nothing positive happened today. And it is not because of any arguments which were advanced, because the arguments which have been advanced could have been much better. I mean, that's a given. The case is not being contested properly. That's a given. But the issue is,
So are you
yesterday
saying
there
that
was.
the petitioners, are you saying that all these lawyers, whether it is Kapil Sibal, whether it is Prashant Bhushan, or whether it is Vrinda Grover, they are not putting up the arguments the way it should have been?
Yes, without
Okay.
any doubt. They have not done their research properly. They are not able to assert as they should. But having said that, I would once again reiterate that even if best of arguments were advanced, the chance of success are absolutely abysmal. Not because they don't have merits. They have merits. Their cause has merits. Their issue has merits. It is an open shut case, despite the fact that they are not able to place their facts correctly, including the one that this entire exercise is a criminal act on the part of the election commission. Nobody is saying this. Something which is done, the horse, the law formed by the parliament and the provisions in the constitution is a criminal act which is being performed by the corrupt officials of the election commission. Nobody is saying this in so many words. So therefore, the case is not being properly argued. I would be saying this very clearly and categorically. Having said that, there is no need for an argument because this is an illegal act. Where is the provision in law to hold such an exercise? That the election commission has to tell. They are not able to tell this because there is no provision in law to hold this exercise. Absolutely, there is no provision of law. The provision of law, when an electoral list is formed, if you want to delete some names, there is only one provision, and that is described in section 22. There is no other procedure. At best, 23. So why are we having this case? And why are we putting this ball in the court of the Supreme Court so that some order may come which will even dilute the agitation which is picking up? So whatever positive signs I saw today, and one of the positive signs was that Justice Suryakant said that we are proud that our citizens have approached Supreme Court. That the remark of the record remark shows that yes, there is there is a sense of responsibility which is dawning on the Supreme Court judges
No, but
that
when
they
you
have
say,
to.
just allow me to interrupt you, when you say that there is a sense of responsibility which is dawning on the Supreme Court, but at the same time, the same Justice Surikant said that this SIR largely looks like a case of trust deficit and nothing else. Now, is that a responsible statement?
Therefore, I'm saying that the case is not being argued properly. Therefore, this window to the judges is available to say like this, to make statements like this. When you
Okay.
argue this case, that here is the book. If I was arguing the case, I would have just given the constitution and the book and the manuals of the election commission. Where is the provision of holding this SIR in this format? Just ask the election commission to show this. That would have at least saved the country and all of us from these remarks which are coming forth from the honorable judges. But even if best of arguments are advanced, the result is going to be the same. I'm telling this because the petitioner always comes and says, in these matters, they say that it's a constitutional body, which is, and we have no doubt over their credibility. Nobody says that election commission officials are committing theft. They are fraudsters. They are cheats. If you don't say these things in so many words, although there is plethora of evidence for that, then there is no point in arguing and going to
No,
the
but
court.
also, Prachar, look at the tone and the tenor of Justice Surikant and also Election Commission's lawyer Rakesh Dwivedi. Now, say for example, when Yogendra Yadav presented two people today before the court whose names were in the deceased list, and he got them that saying that they are alive as a proof. And to that, Rakesh Dwivedi says that what is this drama? Because he was trying to give the exact population of Bihar according to the government's projections in 2019. So he said that what is this drama? And rather than presenting them here, why don't you help them upload their enumeration forms? Now, doesn't that show a large, I mean, a kind of an indifference on the part of the election commission to all these problems, no matter how many proofs you or how many
See,
evidences you present
see,
before the court?
either 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 you are so naive to have gotten carried away by the remarks of the Supreme Court that you show honorable judges that you show us 15 cases and we will set aside this entire exercise of SIR.
That, no,
If
Justice
you are
Bakchi did
naive
mention
enough
it
to
last.
get carried away by that statement and then present two people like this, and these are facts. Facts are not discussed in Supreme Court. You have to understand this. These are debatable questions of fact. Whether they are same people or not, who is going to take that evidence in the Supreme Court? So therefore, these are the top lawyers of our country. Does the Supreme Court take evidence? These petitions are argued with the presumption that there is no dispute on facts. Both the parties will agree to the facts. The moment you bring in factor in facts which are contestable, you that is the end of the case in Supreme Court. Everybody understands this, but you see, everybody is trying to uh, put up a stance and showing to the world that we have done our duty and it is the fault of the Supreme Court. So that's their best case scenario. If they are working for that, they are only harming the cause by diluting the people who want to protest on streets, including the leader of opposition and the 300 member of parliaments who have actually taken a very, very revolutionary step. I have not seen 300 member of parliament marching on the streets. The Supreme Court, as I was saying from the day one, and I'm saying this again, if they have some sense of responsibility, the people who have brought this case before the Supreme Court, if they have some sense of responsibility towards the nation, if they have some sense of actual concern for saving the democracy and the constitution and the election process, they should withdraw their case. That will be sending a message that, and then that will strengthen the campaign at
So
large,
you are
which will
saying
which will
you are saying that this
withdraw
case
their case tomorrow morning first thing. We don't want to pursue this case in view of the statements which are being made by the Honorable Apex Court. End of the
Hmm,
story. Nothing is going to happen. Nothing. Rather, we will be more powerful on the streets then.
right.
But these people will not do
You
it.
are saying that
I'm telling
withdrawing
you,
the SIR
Yogendra
case,
Yadav, see, Yogendra
right?
Yadav Sahab, you've taken his name. He is an agent of RSS. I've been saying this long ago. He's a proponent and supporter of the electronic voting machines. What more proof
No,
does
but
it?
he's producing evidence
It's all
in the form of
drama.
people
It's
alive.
all drama. He will get all the coverage in the criminal media. He will get all the attention from the honorable judges of the Supreme Court. But net result will be zero. He is a supporter of EVM. Anybody who remotely supports EVM is a supporter of RSS. End of the story. There cannot be any discussion on that.
No, but I'm just looking at Twitter and what is trending, Pracha. I want to ask on you that Aadhaar is not the citizenship proof. Supreme Court of India has supported the Election Commission stance during the SIR of electoral rolls, stating that Aadhaar cannot be considered
I will.
conclusive
I,
proof of citizenship for voter verification. Yes.
see, and we will, and see, therefore we will expose. And I am glad that you are having Dr. Pyaralal Garg here. See, we are trained lawyers, but he called me up one day and said all these top lawyers, and I'm now I can say that because the cat is out of the bag, and let us make our last ditch effort. He called me up one day and said to me that these top lawyers have not read Section 23 of the Representation of People's Act. Just ask him this. Did he call me and told me this? I knew it from the day one, but I was hiding it as a strategy. I was not divulging it in public domain because I want to surprise in my cases. I want to spring a surprise on election commission. That is my strategy always. This is how we win cases. But it is written in section subsection 4 and 5 of section 23. Aadhaar is the this is a document which is a substantial proof of identity. It's the law of the land, and the Supreme Court doesn't know it. I don't believe this, and the honorable judges don't know it, and all the top lawyers who are arguing that they don't know it. They just have to show section 23, which parallel Garg Saab could find out. Forget the top lawyers. So this kind of arguments which are being advanced. So this Aadhaar card business would have gone out of the window in 1 second. Anybody doing it? No. Then these people become experts of election law. Mr. Yadav and so on and so forth know nothing about practical aspects of law of the election and no zero zilch negative of what happens on the ground during elections. See, the biggest problem is in detail. Devil lies in detail.
No, but Pracha, my question, and after that
Whatever
I'll go to
procedure election commission officials apply. See,
no,
SR
but
even if SIR is obliterated, same mischief will be done by the officers. Now, let me tell you, BLOs, government officials, they are chosen in consultation with the RSS. When we say this, Supreme Court will say, what is the proof? Now give them the proof. Taking out proof of this will again take a Herculean task like Rahul Gandhi ji performed and his team performed. And the Supreme Court will say we can't go into details of facts. So why do you even go to Supreme Court to lose cases? To put the agitation on a weaker footing. See, this is how it happens. BLAs, they are talking about BLAs. BLAs, you see, apart from BJP and RSS, no political party has got the wherewithal, the money, amount of money, which is required to keep such a large army of booth level agents. And then shamelessly, election commission comes out in the press, makes public statement after public statements that where were your BLAs? Forgetting altogether that they are being paid money, they have the sole responsibility to bring, uh, to ensure that there is a voter list which is impeccable. It is not the responsibility of political parties. Political parties do not even figure in the Constitution of India. In elections, as envisaged by the Constitution, have no place for political parties. It was only brought in by way of the Representation of People's Act by the Parliament. So, Election Commission is the whole sole agency of ensuring free and fair election, and the first job of theirs is to ensure that each voter and citizen who is above age of 18, as Rajiv ji did it as a prime minister. Before that, Ambedkar Sahab determined the age to be 21. Rajiv ji reduced it to 18 years. So every person who has crossed the age of 18 years, it is solemn duty, the first duty of election commission to put that person on the voter list. And once the name is on voter list, there is one procedure that you have to give notices to individual voters and give them a chance of hearing. Only then you can remove the names. This is hard law, hard legislation. There is no doubt about these things. What are you arguing in the Supreme Court? I don't understand. There is no way provided in law to remove names by way of SIR. There is no provision in law once your name is rightly or wrongly in the voter list. Now, what is the argument going on? So it is absolute waste of time and diluting, and it's helping the RSS and BJP. And I'm
So
afraid
you
that
are
they
saying
are
that this
doing disservice.
right. So you are saying that this SIR case in the Supreme Court is a complete waste of time. Dr. Garg, I'll come to you now. Who is misleading whom? If you look at the hearing today, the judge, Justice Surekan, Justice Bakchi are saying something. Petitioners have another viewpoint, which Pracha is saying that they did not argue the manner in which it was required. Then you have a viewpoint coming from the Election Commission. What is this case all about? If the
Now,
case is
election
useless,
commission, you see,
it's by law.
please, Neeluji,
Yes.
1 second. Election commission is committing crimes. They are criminals. The officials of election commissions are criminals. They are filing false affidavits after false affidavits. Do not give credence to them by taking their name in the middle of all this. This is between petitioners and the Supreme Court. Election commissions are a bunch of criminals, the election petitioner officials. So we have to treat them in the same manner as we treat criminals. They file false affidavits in court without any fear.
All right. So I'll come to Dr. Garg now for the concluding comments. And I was asking you that who is misguiding whom? What does the case look like? It is a botched case. It's not going to lead anywhere. What do you feel?
Uh, Neeluji, first of all, I endorse whatever Pracharya has said. I did ring him up, and he told me that he knew this fact, but he wanted to keep it concealed for the lower court, district court, high court, whatever because it is always a strategy of an advocate to put a bombshell at the hearing rather than disclosing everything beforehand. Second, I a bit disagree with him on this issue that just Suryakant said, it's very good that you have come. It means had you not come, the people on the streets would have won. Now you have come here. We will see to it. But that is damaged. That is a good thing. Now, whenever Mr. Yogendra Yadav, already I told you, this is nothing but a, even if the Supreme Court has made an observation, I think you remember I made out on this platform itself, on your platform itself, that not to talk of 15, even 100 people dead have been shown as living, 100 people living as dead. That does not mean that the exercise of 7.9 crore people, 79 million, is all wrong. So many people are there. So this was a talk which shows that the Supreme Court is not that seriously taking. One, two, is the Supreme Court, are you to produce people before the Supreme Court? At the most, you can produce a document. You produce a document of, say, not only one, two, three, you produce the document of 100 people. Okay, look at this is a list. I challenge the election commission, put it to the election commission, let them reply. They are dead and living, they have been shown as dead in their list. The election commission come out. Now, once you be election, the Supreme Court is not an evidence court. The lower courts, even the constitution, even the high court is not an evidence court. The court decide, the constitutional court decides the matter on the written documents, on the written arguments, on the arguments or on the written documents, and you can file the written documents also, arguments also. Here, I agree with Prachaji that still we have a chance tomorrow to say, okay, my lord, we withdraw this case. Prachaji says he knows it better whether to say it toward the bench or if I am to say, I will say, my lord, I have seen the election commission is committing all frauds, signatures, and all that, and is finding false evidence. And my lords are to decide only on the affidavits filed by two. So we withdraw our case because we don't want that the election commission should file more false affidavits only to defy the law. They can withdraw by in a sort of protest against the commission rather than against the court. To my mind, I don't know what, because indirectly it is against the court also, that he is the election ECI is filing false affidavits and you are accepting, and they should quote it. That look here, this has happened, this has happened, this has happened, this has happened. The election commission is trying to conceal all these facts from this honorable bench. The election commission has done this, election commission has done this, so we withdraw it because now we are tired of. Let it be. There's no harm. We withdrew an agitation by saying government is shameless. We are tired. We cannot kill the people, patients now anymore. Keep them suffering. So we withdraw the agitation. We can withdraw the petition, and it will be better. I agree with Prachaji. It will be better so that no adverse observation comes. Look here, what is coming? It is only an observation. It is not a rule till now that the election commission can decide the citizenship of a citizen, which the election
Right.
commission not authorized. No, the total lie is being put topsy-turvy. So
Right.
this is the
All right.
biggest mistake they are doing. They will do it, but they will not withdraw because they believe the political parties do not do anything. It is only the court which does it.
Right. So we'll have to wait and watch. Tomorrow is the day two of the hearing, and we'll have to see what happens tomorrow. What are the kind of arguments? Thank you so much. We'll have to end it here. Thank you so much, Dr. Garg. Mahmood Pracha, thank you very much for joining.